Salvatore Antonucci versus Motor Will Lofts. And this is file number 23-00617SC. Sir, can you state your name, please?
Salvatore Antonucci.
You, and then your name, ma'am?
Sheila Sharapata.
Okay, and you're here on behalf of Motor Will?
Yes, I am.
Are you an employee of Motor Will?
Yes, I am.
Thank you. Today was the date that was set for a hearing for a small claims appeal. And let's see here. There was previously judgment entered in favor of the plaintiff, it looks like. And are you appealing that?
Yes, we are.
Okay. All right. Well, then we'll take the case from the beginning. Mr. Antonucci, you can state your claim.
Sure. Is it okay if I share my screen to present some materials?
Yes, let me make you a co-host and then you can do that.
Thank you.
Correct.
All right. So thank you for everyone's time. I want to be as concise as possible, but the main thing here is that the purpose of this, my complaint was just because I don't feel like we were fairly assessed for the damages of the unit that we had rented for Motor Wheel Lofts. So through this process, I hope to be fairly assessed for the damages, and then consequently be appropriately refunded for our security deposit. So before we get into the actual reasons for the security deposit being taken, I'd like to go over some important dates. So we began moving out on June 4th of 2023. In this message here, you can see.
Can you go back? You're moving a little bit quickly.
Oh,
I want to see these dates. Okay.
Sure, yeah. And they're going to come back up. They're going to come back up as well. But anytime, yeah, please let me know.
Okay, you can proceed.
Okay. So the first important date is June 4th of 2023. So this is the date that we began moving out. I say we, my girlfriend, Victoria Thatch, is also on the lease, and I'm filing this claim in our behalf. But in this message, we let them know that we would be moving out and that the lease obligation is for 6/30, so move out date on 6/15. And they let us know to schedule a time to request to reserve the alley and elevator. And so I asked for June 4th as a time to reserve it. And then we had heard that's good, June 4th at 1 to 3. That's the date we began moving out. And then I wanted to confirm.
Can I ask you a quick question? When did you contact them to request June 4th? Is this the Monday, May 22nd?
Let me see. I requested June 4th. Yep, May 22nd.
Okay. Okay, you can continue.
Okay. So on looks like May 22nd, I was given June 4th as I was confirmed June 4th. And then I wanted to confirm too that we wouldn't be moving out on the 4th. So I said, thanks. I just wanted to confirm that the dates are just to reserve the alley. I believe that we will need a few more days to move after this date. So our final move out date will likely be closer to June 15th. So that way it would give us, we would move the big stuff on June 4th, and then we would move other things more slowly throughout the week. And I got a response from Ms. Sharapata saying, that's great. If you need a second date closer to June 15th, let me know. And that was also sent on May 22nd. So that establishes the day that we began moving out. Now, we took quite a few more trips back and forth between June 4th and the 14th, but we finally moved out on the 14th of June 14th, 2023. And on that day, I sent a message via the resident portal saying, hey, I just want to leave a message to let you know that Victoria and I have finished moving out. You may move forward turning it over for the next tenant. We left 3 sets of keys along with the key card, Wi-Fi router on the counter as instructed. And then this is my current address, the forwarding address. And I asked that they send that security deposit there as long as any future correspondence. So on June 14th, I sent that message. I didn't get a response back though, which was kind of concerning. I thought I would get a confirmation message from them, but I didn't get anything. So on June 28th, I sent a follow-up message also through the portal. And this one I said, hey, I'm just writing because I wanted to confirm that someone received the message I sent on June 14th about where, the forwarding address. And I just said, hey, if you need it again, here's the address again. And also please respond confirming that you received my message. And then any information regarding the status of the security deposit would be greatly appreciated. So that was, I think, 14 days in between these messages, and I hadn't heard anything from anyone at Motor Wheel in that time. But on the same day, I received a message back from Ms. Sherpada saying, we did receive your addresses, your address. Security deposits are usually returned in less than, security deposits are to be returned less any damages 30 days from the lease end date. I usually get them done sooner. Thanks, Sheila. And that was sent on June 28th as well. Now, the move out date that's listed in the lease is June 15th. Sort of confusingly, there's also an end of lease date. I don't know if that's pretty conventional, but that's how it was listed on this lease. But the date that we terminated occupancy was actually on June 14th, 2023. I figured that was something that was worth mentioning. Now we didn't hear back from Motor Wheel since I think I said that was the 28th, again until July 17th. And this is when we were actually mailed the notice of the security deposit, and we got a move out statement. We will look at this message again, but I wanted to show it here on July 17th. This is the first contact we had since, the confirmation message, and they said that the painters had to paint 1,264 square feet of the unit to holes, marks, and stains. The painter sheets attached. We'll look at that as well. And then that the total cost of security deposit would be deducted is $1,162, and that we would get a check in the mail. We also got this in a separate message. This is the statement, the move out statement, which again, we will look at in time. But on the dates here, it says the statement date was July 17th. And also I wanted to point out that the move out date of 6/15 is written there as well. And then the last important dates to mention, the final contact that I had with a member of the Motor Wheel Lofts was on July 21st. I think that was a phone conversation I had with Mr. Hepler, who is, I think his title's owner or president. I'm not sure, frankly. I knew him as my landlord. And finally, after that final contact, I wrote a letter formally outlining my objections on July 24th, 2023. Are there any questions about the dates here?
No questions about the dates.
Thank you. So I want to talk about the claims that Motor Wheel has made. So as we were seeing that message again sent by Ms. Sherpada that the unit required 1,164 square feet worth of holes, marks, and stains, and that the cost to repair these damages, the so-called damages, was $1,162. So that was outlined in this email message. Again, I wanted to show it, 1,164 square feet and $1,162. And again, holes, marks, and stains, which will be important language later on. They also sent along this painter sheet. Now, they didn't explain exactly what was being communicated in this painter sheet, but I was able to figure it out after looking at it for a few minutes. So you can see these are all of the different areas that they said were damaged. So you see here there's stains, command strip, stains. There's also drywall repair right here, which will be important later. And then these letters and numbers. So those are like walls. So I'm assuming this is bedroom 1, bedroom 2, bedroom 3. And then the square footage of each of these walls was calculated. And then when you add all these numbers up, that's how they get the 1,264 square feet. So you can see that the square footage is added up from the apartment, like all over the apartment, which again will be important later. The move out statement, I want to take a closer look at the move out statement that they sent as well, along with the painter sheet. So the only thing on the paint, this is the entire move out statement. I did not receive anything else other than this. And as you can see, we'll talk about later that there's just I'm sorry, that's not what I meant to do. There's a date and then just the description of damages and then that total unpaid damages charge there. And we received $213 back. So now I think it's important to actually take a look at the way that Victoria and I had left the apartment, the apartment's condition on move out. There's a video that I took on June 13th. This was before we took the last load of our things into our car. This was us leaving the keys on the apartment counter. If at any moment you'd like me to pause the video as well, please do let me know, but I will pause it at a few moments as well. So when we first enter, I do say you can see there is damage to the drywall here in the entryway. And one thing I do want to make very clear is that I am not trying to argue that there was no damages that needed to be repaired. What I am trying to argue is that we are being held responsible for repainting and repairs that should fall under the category of normal wear and tear. But this is one of the areas that we did damage. There were some command hooks that were improperly removed. So it took the paper off the drywall here. You know, if you know the size of a command hook, you can imagine the size of that damage right there. That's right upon the entryway. Coming into the apartment, entryway here, the opposite wall. This is the bedroom. You'll notice that there are command strips up there that just weren't peeled off. For some reason, that was even on the painter sheet, which if you remove them correctly, there shouldn't be a problem, unlike the ones I did, I admit, remove incorrectly. But as you can see in the bedroom here, this looks fine. I don't know what stains are present that we're being held responsible for. Even if there were stains, we shouldn't be held responsible for them, but we'll get to that later. This is the bathroom. As you can see in the bathroom, again, it needed to be repainted, supposedly, from damage that we committed. I don't see anything in this bathroom. This is the closet. You can see we still have, this is like the last bag of stuff we had. It was wrapping paper. We still have our stuff in here. We took like 2 loads still. There's a broom in the corner because we cleaned up. Oh, I'm so sorry. I meant to go back just a minute. Because there's a spot right here in the kitchen. You can see that little white speck, and there's another one right there. There were small drywall anchors that were in the wall. So again, that's the second wall that we admit was quote unquote damaged, right? We knew when we put those anchors in that there would be a deduction from our security deposit to fill those holes. We expected that. But as we'll see later, we were not expecting to be held responsible for other damages because we didn't think there were other damages. So there's the bedroom, or there's the living room. There's Victoria, my roommate, my girlfriend, and that's that. Is there any part of this video you'd like to see more of?
Oh, no, I'm fine.
Thank you. let me see if I can, I don't know why it does that with the full screen. Here we go. So there's some screenshots that we can return back to. Again, those are the two holes in the kitchen. I think we went through the video very carefully though. Again, those are the entryway damage. That's the entryway damage again. And then there's also this video that was shared with me that was in the resident portal that Motor Wheel uses to communicate with its tenants. And this was their walkthrough of the apartment assessing damage that I want to watch with you all.
Unit 314.
Oh, and I should preface this by saying, as we're watching, I don't know who is in this video assessing the damage, but they're going to mention what they think needs to be repaired.
Scratches on the door. Wall repair right inside the door. Main wall needs to be painted. The hall wall into the living room. Behind the kitchen sink needs to be painted.
I can't tell if it's the quality of the video or if they're making things up, but as you saw in the video I took, there really doesn't seem to be any damage there. That's a
Drywall repaired. Accent wall needs to be painted. Bedroom wall needs to be painted. Scratches. Scratches. Drywall repair.
again, those are command strips that
The entire bedroom needs to be painted.
Yeah.
Bathroom wall needs to be painted. One wall in the bathroom needs to be painted. The rest is okay. And I think that is it for paint damage in this unit. Let me look at the windowsill. Windowsill needs to be painted also. And this is unit 314.
Okay. So that's the condition of the apartment that we left it in. You saw the two videos and some screenshots as well. So now I want to talk really quickly about the issues that I have with the handling of the security deposit. And I actually have a lot of issues. There's three of them really. First things first, we didn't receive a proper itemized receipt. We'll talk about that in a second. We'll also go into more detail on how the notice of the security deposit wasn't received within 30 days. And also, tenants should never be charged for normal wear and tear, even if, I don't even think there is normal wear and tear there, but even so, if there were, we shouldn't be charged for it. So the proper itemized receipt, from my research, from what I can tell, you need to be given, after 30 days after the termination of occupancy, an itemized list of damages claimed for the security, for which the security deposit may be used as provided in section 7, including the estimated cost of repair of each property damaged item and the amounts and bases on which the intends to assess the tenant. He intends to assess the tenant. So what we see, also the inventory checklist. I have not seen the inventory checklist that they've made. All I got was that video and the painter's sheet. But as we see on the move out statement, all I get is one line for damages. Now, my interpretation of that law, I mean, I'm not a lawyer. I don't know what that exactly should look like, but from what I understand, it should give me a breakdown of how much drywall repair should have cost, how much painting should have cost, how much other repairs they may have had to do should have cost, but we don't see any of that. Instead, I just got a painter sheet that wasn't explained at all. So this makes it nearly impossible to tell where the money that they're withholding went. I have no idea how much any of their repairs cost. So that's my first big issue. Right, they did have this painter sheet, but like I said, that's not an itemized receipt. That's not giving me costs. My second issue is that the security deposit wasn't received within 30 days. So again, from the research I did, I saw that failure by the landlord to comply with the notice of damages requirement within 30 days after the termination of occupancy. Again, I'm not a lawyer. I don't exactly know how these terms are defined, but termination of occupancy seems to me to be the day that the tenants move out, not the date that the lease terminates, which again is really weird that it terminates after we're required to move out. I've never seen anything like that before in all the apartments I've lived in. But as we established earlier, I moved out on June 14th, and in the move out day from the lease and also from the move out statement, it's June 15th. And we didn't get a notice of a security deposit form being mailed until July 17th. So that's 34 days. Again, this was not done in the proper time frame. It was not done in the proper detail. That's a huge issue for me. Now, the last issue I have is that tenants should not be charged for normal wear and tear on an apartment. So again, I did some research here that says that the security deposit may be used only for the following purposes: to reimburse the landlord for actual damages to the rental unit or any ancillary facility that are the direct result of conduct not reasonably expected in the normal course of habitation of a dwelling. So normal habitation, paint is going to, I don't know, it's paint. You got to repaint after a few years. I don't know what they're expecting, but so they're saying that they needed to paint 1,264 square feet of holes, marks, and stains. Now the holes, I understand, that does not fall under the category of normal wear and tear. I would argue that the holes in the entryway and the kitchen are my responsibility. But the marks and stains, I would believe, would fall under the category of wear and tear. But even if they do fall under even if they don't, I didn't see any marks or stains that needed to be repainted. Regardless, this is what we were charged for. So
Can you go back to the last, can you go back to the last one? It says the
This
total cost being deducted from your security deposit is 1,162 square feet.
yeah, I don't know what that.
I don't know if that means, we'll find out later, I guess. Okay.
So this is the painter sheet that they gave me. And so again, I had to figure all of this out on my own. They did not explain any of this to me, but I could tell. So these are the drywall anchors that we put in the kitchen. Again, we admit to that. And that comes down, if the K means kitchen, that is 18.3 square feet, I believe. This right here is the damage that we did to the entryway. So hall 1 and hall 3, maybe? I'm not sure, but if I'm being liberal here, that's 34 plus 109 square feet. That's not 1,200 square feet. Everything else that needed to be painted then is not holes or damage. This is stains and what else? Marks, which again, I did not see, but they felt the need to repaint them and then make me responsible for paying for that paint work. So from what I can tell, all these other ones that aren't circled are also my responsibility. That number here adds up to 1,200. Now, on their leasing agreement that we did sign, it does say, please note that any nail hole requiring wall repairs will be deducted from your security deposit at a minimum of $50 per wall. So again, I was willing to pay at least $50, $100, even $150 for those drywall anchors that we put in the wall. We knew going in that that would be deducted. We did not ever expect to be deducted for the condition that we left the other walls in, which, if you ask me, was more than okay. So my conclusion that I want to go over here is that there were 2 walls that were damaged and were in need of repair. I admit that. Now, the lease did stipulate that there's a minimum of a $50 fee per damaged wall. And again, we would be happy to pay that. Now, in the previous ruling, since there wasn't an itemized receipt, and we don't know how much those 2 particular walls cost to repair, the magistrate ruled that each wall would be, we would say that it would be at least $50. So they would be reimbursed $100 for my deposit to cover the repairs to those 2 walls that we were responsible for. Frankly, I am more than happy to, I was totally okay with this ruling, given that I don't want the whole security deposit. I don't think I was entitled to it. I just want to be given what I actually should be given back. And the fact that they had $100 going back towards them, I think is okay. So that's my case. That's all I have really. Like I said, I just want to be fairly assessed, and I want to get this over with because I do not have any more vacation days to take to argue my case.
Thank you. You
Thank
can
you.
stop the share screen, please.
Yes.
And thank you for the presentation. That might be a first for me. Now, Ms. Sharp, is it Sharapata? You're muted. Can you unmute?
Can you hear me now?
Yes, I can. Thank
Okay.
you.
Hi.
Okay. And what is your role again with Motor City?
I handle some leasing, I handle administrative, I handle accounting, so I do quite a bit.
Okay, sounds good.
Right.
And were you the person who did the walkthrough?
I did not do the walkthrough. Our painters do the walkthrough, and they send us the video and the photos. So it's a third-party painter. They charge 92 cents a square foot, and when they paint walls, they paint them seam to seam. And then when there's drywall repairs, it has to be patched, it has to be sanded, it has to be primed, and then it has to be painted. It's a 2-day process.
Oh,
So-
I'm not disputing those things.
Okay.
But just
Yep.
in the interest of time, I just want to get straight to the point because as you can see in this PowerPoint, which before you even got to the point, the law is the law where it comes to what the responsibilities of the tenants are and what the landlords are. So one of those responsibilities is that you need to send notice of the security deposit within 30 days and of the termination of occupancy.
So
Your lease.
Mr. Andalusi,
I wasn't finished talking.
Okay.
And so one of those things that stated in your lease was that he was to end his occupancy on the 15th of June. So that letter was supposed to be to him by 30 days after that. Why was that not the case?
he actually, we do it based on the lease end date because you are responsible for the unit until your lease end date. And
that's not what the law says. The law doesn't give you an opportunity or the leeway to decide when you're going to do it. The law says you're supposed to do it within 30 days of the termination of occupancy. He terminated his occupancy actually on the 14th, but notified you that by the 15th it'd be done. Not by the time that you decided he was going to leave the lease. And also based on what he showed, you all said he had to get out the house by the 15th anyways, even though his lease ended 15 days
Yeah.
later. So,
Yeah.
so the court, to cut through the chase, I understand that you all made the decision that you're going to go by that date. I actually think there's a whole nother issue with the fact that a lease ends on one day, but you're telling them they need to be out 2 weeks before the end of their lease. That's a problem, but that's not an issue before the court. Nonetheless, I agree that you failed to comply with the law when it comes to providing notification within 30 days. Why was he not received, or why did he not receive a appropriately itemized receipt?
So with the email, I send the email that explains it. I send the painter sheet that explains the charges. I upload a video and I tell them that that is all available to them to take a look at, and that outlines the charges. So I use the evidence of what the painters provide to me to help itemize everything out for them. So that
Okay,
is,
so an itemized receipt would be painting this or filling this wall. This is how much the drywall cost, and it's how much it was for labor, and this is how much it was for materials. That's what an itemized receipt does. What he showed, and maybe you have some other evidence that he didn't show. I don't know. If you do, you can show it to me. But what he showed was a handwritten thing that he had to figure out himself what that meant. And that's unreasonable. No one has to take a copy of your painter's form where he presumably used the square footage of the house. And before we get here, I'm just going to say it's completely unreasonable to me that a renter doesn't understand that you got to paint a house, period, before you re-rent it. And you don't get to charge the tenant for repainting a house. You don't get to go and say wall number 1 needs to be repainted. That's ridiculous to me. I wish I would move in somewhere and they didn't freshly paint the walls. You don't get to make them responsible for you repainting the walls. Before I was a judge, I did real estate. When I was in school, my mom was a property manager for a large property complex. This is normal. Of course, it wasn't in the state of Michigan, so maybe you all are a little different when it comes to the mindset of what you need to do. The mindset of what you need to do, but if you rent an apartment out and people move out, they're supposed to leave it in broom swept condition. There's no, and some tenants will take the time to refill the hole so they don't get charged if they have pictures and things of that nature on the wall. But the expectation, I think, is reasonable that the owner is going to go in there and get the property cleaned and the walls painted, no?
Some, yes, normal wear and tear. Our apartments rent usually for a longer year, and they are freshly painted in between tenants. We call out in our move-in packet, and I can show it to you, the fact that you're not to put holes in the walls, scratches and marks. That's tenant responsibility. When people live in our units more than a year, which is usually the case, then we start writing off more for wear and tear. And we did, there were walls he was not charged for. So there was some walls, and for example, she mentioned the door. They brought in their bike or whatever, and they scratched up that door. We refinished that door for free. So there was things that were written off as normal wear and tear. I also want to call out that Andalusia had an additional lease that he was responsible for, and we let him out of that lease obligation early. They asked to extend for a period of time, and
that's not relevant to this. That's why I don't want to hear about it. It just causes confusion trying to mix things.
And
but
the other
law
part,
says you can't, the law says you cannot charge the tenant for wear and tear. So you violated that. Last question, because you didn't give them an inventory checklist either, it looks like. And so I think the lease does say, though, that they are responsible for the holes. And so why wasn't there at least at bare minimum itemization as to how much it costs to repair those holes?
Because we go back, like a huge scratch or a gouge on the wall from a couch that was moved, that still is something that we have to paint seam to seam. And it's in the move-in packet that if you put your furniture against the wall and you leave those marks, that you'll be responsible for them on your move out.
I
And he was
recognize
given,
that, but there was no, do you have a better video? Because the video he showed
I
that
did.
you all
I do, and
provided
I have some photos.
doesn't show
I-
me any damage. And then also
Okay.
the video he showed, I only see essentially the holes that there was some drywall hole in the kitchen,
Yeah.
it looks like, or ankle hole in the kitchen. There was some drywall damage in the entryway. Those are two walls that I see in his video. The one that he played that he said he received from you was definitely there was a clarity issue. So I didn't see, to be honest, if I viewed that, I would consider them to be model tenants, and I don't understand why they're being charged.
Okay.
That's the other thing.
So-
Why are they being charged? Why is the charge? And that's why it's important to give an itemization. Why is he being charged the amount is the dollars per square?
It's per
unit? I'm
square
really
foot.
confused
It's
about that.
92 cents per square foot, and that's what we're charged by the painters. It's a pass-through charge that we pass through
Okay.
to the tenants, and then we write off.
That wasn't itemized to him then, correct?
It was given to him. He was given the painter sheet, and we told him, and we talked to him as well, and we told him it was 92 cents a square foot.
No, the law doesn't say you get to talk to them. The law says that you need to give them
All
an
right.
itemized receipt.
Ma'am, he was given the information. So
And an itemized receipt?
sent him an email. I sent him the painter sheet. I sent him a video, and I
Can
sent
you
him
show me the email that you sent him?
that you saw. That was the email I sent him, and then we spoke
Which
with him
one
after
was
that.
it? Well, I
He,
don't want to hear about what you spoke about. I want to know about the itemized receipt. Can you pull up the receipt on the email again for me, sir?
Yes, one moment, please. Oh, there it is. All right, one moment. There's,
This is the email, but apparently, which was what he sent to you all after he received, I guess, notification that he was going to have a deduction. It says your total cost being deducted from your security deposit is 1,162 square feet. Where does it say that's because of the drywall and X, Y, and Z, and that is 92 cents?
yeah, the
per
painter sheet.
unit?
The painter sheet shows everything, and it shows this, what walls they
Can
are.
I see
and
the painter
everything.
sheet?
That's the
Okay, I
painter.
see the painter sheet. Where on here says that he's being charged 92 cents for each of these things?
I don't know that it does. I may have made a mistake on the email, and I'm probably meant to write
Okay.
by
Judgment in favor
92
of the
cents a square
plaintiff.
foot.
Judgment in favor of the plaintiff for $1,062 plus costs. You violated the law not once, twice, but 3 times, and there's no way to get around that. The law requires that you provide notice within 30 days of their termination of occupancy. You don't get to now construe your own interpretation of that.
I'm not. I actually have some more things I want to show you, but it's,
So judgment in favor. I was going to explain that, but I've already been, I think, far more lenient when it comes to people talking over me. That's a pet peeve of mine, because as you can see, I will sit there quietly while you talk. But one thing you won't do is talk over me while I'm talking. I run the courtroom, you do not. And so judgment in favor in total will be $82.35 in cost plus $1,062 in damages. I do agree, at least based on what he said the lease states, and you provided no evidence really to support what you're saying, but that he did put damage in the walls, at least 2 walls, and those needed to be repaired, said that there'll be a cost of at least $50. He didn't receive an itemized receipt, and calling him later and telling him how much that it will be cost is not an itemized receipt in writing provided within 30 days. And you can't charge him for wear and tear. You can't charge him because you had to paint 1,162 square feet of the apartment because he lived there for over a year or whatever it is. So let me see here. I'll present an order. You'll get a copy of it in the mail. Do you have any questions?
no.
No.